Hello students, my name is Abhishek Sudhir and I am an assistant professor at the Jindal Global Law School. Today, we will be discussing Module 6, Evolution of the Right to Free Speech and Expression, which forms a part of paper Civil and Political Rights of the EPG Pathshala. The right to free speech and expression is the single most important right in any democratic society based on the rule of law. If one cannot speak his or her mind, then what is the point of saying that your nation is a democracy? This module will introduce you to some of the landmark events which contributed towards the development of the right to free speech and expression in its present form. We will take in developments predating the American Revolution and post the American Revolution. This is because in the modern world, the First Amendment to the American Constitution is a turning point in the development of the right, as it was the first time that it was codified in a written constitution and has survived since then without its scope being limited significantly. This module, therefore, has been classified into two principal sections: developments predating the First Amendment and developments post-dating the First Amendment. Now, we come to the learning outcomes of this module. The first outcome is the first proposed outcome is to give the students an overview of the historical development of the right to free speech and expression. The second objective is to help the student understand the manner in which the right to free speech and expression has developed gradually through political and apolitical discourses. You're looking here at an artifact of the First Amendment to the US Constitution. But the development of the right began several centuries before the US Constitution was actually formulated. Now, in the modern world, America is known to be the champion of free speech and democracy, undoubtedly. The country is in fact known for its extremes when it comes to allowing speech, be it the burning of their own flag or a religious holy book. The concept of allowing free speech so as to allow for different perspectives is much older, as I've said, than the US of A, and has been in existence for several centuries. You're here looking at Plato and Aristotle, two of the titans of ancient Greece and two of their greatest philosophers, arguably. Another one of their great philosophers was Socrates. Socrates, after being condemned to death, refuses to escape, as he believes that since he has consented to the laws of Athens for 70 years and has enjoyed the rights and privileges conferred on him by doing so, it will be wrong on his part to withdraw his consent merely because his life is under threat. Socrates was making a larger point. He argues that his obedience to the law is as imperative for him as was his obedience to laws which would abridge his belief and the expression of it. What Socrates is essentially trying to say is an individual should hold his own views, and in an ideal scenario should be allowed to profess their views. But if the laws of the land do not allow for the profession of those views, for the propagation of those views, then for Socrates, having consented to the laws of that nation, like he had done with the case of Athens, he must now not disobey and should not leave. He's entitled to disobey the law, but he has to face the consequences. As he says, his obedience to the law is as imperative for him as was his disobedience to laws which would abridge his belief and the expression of it. Let me explain a little further by using Plato. Plato draws a parallel with Socrates' experience, stating that when a government by passing a law tries to limit the freedom of a person's opinion, that person has both the right and duty to disobey such law. But when by regular procedure his livestock or property is taken by law, he must comply. What this essentially means is that when a government limits a person's free speech, the right to his free speech, he has a duty to obey that law, to disobey that law. So let us say a nation passes a law that says if you say A, you will be sent to prison for 1 month or you will be sent to prison for 1 year. You have a duty to disobey such law if you believe that you should not be persecuted for the opinions you hold. But at the same time, you also have a duty to obey the law which says that you will be sent to prison for 1 month. That is what Plato and Socrates are trying to get at. Now let's come to Athenian democracy. The Athenian democracy could not have survived without free speech. For without free speech, there is no democracy. There was absolutely no prohibition in Athenian democracy. Common citizenry, addressing the village assembly, were able to speak their mind freely. Even outraged farmers would often speak out of turn and interrupt people. Now let's come back closer to home and the Arthashastra. The Arthashastra is a text that was written at the end of the 4th century BC by Cornelia, dealing with various theories and principles of governing a state. In Arthashastra, Cornelia, or Chanakya as he is known, approves of an actor making fun of almost anything, including customs of countries, castes, families, schools, and love affairs. This long tradition has continued to this day in India, where satire is still very much a part and parcel of daily life, especially political satire. However, for Cornelia, criticizing the sovereign, criticizing the king was not permissible. An actor could make fun of anything. He could make fun of the country, of various other countries, of the caste system, of various families, of the schools, of love affairs, of the personal, private lives of prominent citizens. But criticizing the king was impermissible. And Cornelia felt that one who criticizes the king at his own peril. Cornelia states that such persons should have their tongue rooted out. An extreme measure indeed. And here you're looking at a picture of Cornelia, who is considered one of the greatest thinkers in Indian history. Now let's come to the education of a Christian prince by Erasmus. Many of you might have come across the name of Erasmus. The importance of free speech has not only been celebrated in modern democracies, but even in authoritarian regimes, a regime that Erasmus was a part of. Erasmus was a Dutch Renaissance humanist and was the teacher to many of the autocratic princes of his time. Erasmus tried to impose, or rather impress on them, the princes, that in a free state, tongues should be free as well, and that the stability of their rule would ultimately benefit from unvarnished political advice. Erasmus essentially told his pupils, the princes of his day, that they must be open to criticism, because the stability of their rule would ultimately benefit from their ability to recognize dissent, address it, and find a solution, and not simply sweeping that problem or that dissent under the carpet or silencing the person who was expressing a dissenting opinion. Another landmark figure in the development and the evolution of the right to free speech and expression was the English civil servant and a famous poet, John Milton. Milton wrote an influential piece advocating for freedom of speech, and I quote, "As good almost kill a man as kill a good book. Who kills a man kills a reasonable creature, God's image. But he who destroys a good book kills reason itself, kills the image of God as if it were in the eye. Many a man lives a burden to the earth, but a good book is the precious lifeblood of a master spirit, embalmed and treasured upon purpose to a life beyond life." What Milton is basically trying to say is free speech and expression is sacrosanct. And in fact, he valued that even more than the taking of a human life. Staying in England, we come to the Bill of Rights Act, 1689. The Bill of Rights is an act of Parliament, the Parliament of England, which passed it on 16 December 1689. It is essentially a restatement in statutory form of the Declaration of Rights presented by the Convention Parliament to William and Mary in March 1689, inviting them to become joint sovereigns of England. Following the death of Queen Elizabeth, there was a lot of turmoil as to who would succeed to the crown. William and Mary, alas, finally did. And they were presented with the declarations of right by a convention parliament. This convention was embodied in the Bill of Rights. The Article 9 of the Bill of Rights Act provided for free speech in Parliament. And this, interestingly enough, has found expression in our very own constitution here in India. Here's what Article 9 of the Bill of Rights says, and I quote, that the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. The principle at play here is something that has come to be known as parliamentary privilege. Under parliamentary privilege, anything that a member of Parliament says on the floor of the House, on the floor of the Lok Sabha in India, is protected by privilege. Now, you might ask yourself, what is the rationale behind this? The rationale behind this is very simple. When the citizenry elects a group of individuals to represent them in the central legislature, they must speak their mind without fear or favor. They must voice the concerns of the citizens. They must, if need be, even make inflammatory speeches, derogatory speeches, bordering on even hate speech or actual hate speech. And they should not be prosecuted. There should be no sanction for them for speaking their mind freely in Parliament. Because if there is no free speech in Parliament, there is no free speech in the temple of democracy, then what is the point of having free speech anywhere else? Now we come to France. France is interesting for its extreme position on free speech. It can all be traced back to the Declaration of the Rights of Man and of the Citizen, which was passed in 1789. This declaration was passed by the National Constituent Assembly in France on the 26th of August, 1789. The French Revolution was in full swing. The declaration was drafted by Lafayette with the aid of his American friend, the free speech champion, Thomas Jefferson. And the declaration was modeled on the Virginia Declaration of Rights and the American Declaration of Independence, which we will come to later in this module. You are now looking at an artifact of the Declaration of the Rights of Man and of the Citizen. The declaration was based on the concept of natural rights. Natural rights are rights that every human being, irrespective of race, gender, caste, or sex, is born with. These rights are inalienable. These rights are inviolable, which basically means that these rights cannot be taken away by another human being. The declaration was based on the concept of natural rights that human beings possess. Inviolable rights, as I said, by virtue of them being human beings, and the state is obligated to protect these rights of the citizens. The declaration has found a place in the current constitution of the Republic of France and was also present in its predecessor, the Constitution of the Fourth Republic. Now let's actually come to the text of the free speech clause in the French Constitution. Article 11 of the French Constitution states that, quote, "The free communication of ideas and opinions is one of the most precious of the rights of man. Every citizen may accordingly speak, write, print with freedom, but shall be responsible for such abuses of this freedom as shall be defined by law." Now, here is the difference between the French Constitution and the Indian Constitution. In France, Article 11 leaves it to Parliament to define by law what would be an abuse of the right to freedom of speech and expression, whereas in India, what constitutes an abuse is broadly defined in the Constitution itself. France raises many interesting issues on free speech. Let us think of the recent episode of Charlie Hebdo. For those of you who are unaware, Charlie Hebdo was a French satirical magazine that published derogatory cartoons of the Prophet Muhammad. Any imagery of the Prophet Muhammad being depicted is prohibited by the Islamic faith. And many Muslims around the world would be offended by many of the cartoons and stories that Charlie Hebdo ran. Unfortunately, a few months ago, Charlie Hebdo's offices in Paris were attacked by a group of gunmen. Essentially, they were claiming that this was in retaliation for Charlie Hebdo's continuous abuse of their freedom, in their words, of free speech and expression, and for offending the religious sentiments of millions of Muslims around the world. This raises many interesting questions. Should free speech be absolute? Should there be curbs on free speech? As we see in India, there are curbs, but France puts very few restrictions on free speech. And this is reflected in sometimes toxic criticism of their own president or their own citizens. However, France has made a cardinal pact. They've entered into a pact with their founding fathers, with the Declaration of the Rights of Man, which says that free speech and expression will be as absolute as possible. Charlie Hebdo, unfortunately, was a price that they paid, but it is commendable that despite Charlie Hebdo, the French Republic continues to offer the right to freedom of speech and expression absolute protection. Now let's come to the developments since and after the First Amendment to the US Constitution. The First Amendment to the American Constitution is perhaps the most important event with regard to the development of free speech in the modern world. For the very first time, the right to free speech and expression was given a written, codified form in a constitution. The First Amendment, along with the rest of the Bill of Rights, was submitted to the United States, the states of the United States, for ratification on September 25, 1789, and it was adopted on December 15, 1791. The proposal for the First Amendment was made at the same time as the Declaration of the Rights of Man and the Citizen was being passed by the French National Assembly. The First Amendment, along with other rights, were included in the Constitution at the insistence of George Mason. George Mason had earlier drafted Virginia's Declaration of Rights, on which the Bill of Rights in the American Constitution is based. The Bill of Rights is a set of the first few amendments to the US Constitution. Now, coming to the First Amendment. It was eventually drafted by James Madison, who of all people had opposed the enumeration of rights in the Constitution. Madison was against the enumeration of certain rights in the Constitution. He believed that listing out rights might mean that rights that were not listed were excluded from being constitutionally guaranteed. However, Madison nevertheless undertook the task of drafting the First Amendment. The support for the First Amendment was such that there was little or no debate on it, thus making it difficult to ascertain the intention of framers and consequently the limits of the rights granted in the amendment. Now, when we look at the text shortly, you will realize how absolute the right of free speech and expression is in the United States of America, and what a Herculean task the United States Supreme Court has had to perform in limiting these rights. In fact, it was the American lesson that guided our own framers in ensuring that the free speech clause was drafted in a more comprehensive manner, whereby the onus would not be completely on the Supreme Court. Now let's come to the actual text of the First Amendment. The First Amendment went as follows, quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. The part of the First Amendment that is relevant for our purposes here is Congress shall make no law abridging the freedom of speech. Congress shall make no law abridging the freedom of speech or of the press. That is as absolute as it gets. There are some rules of interpreting statutes. One such rule is the literal interpretation or a textual interpretation. What this rule of interpretation basically says is if the intent of the framers is absolutely clear and the language of the legislative enactment is also perfectly clear and there is no doubt, then you must give the text of that legislative enactment, in this case the First Amendment, a literal or textual interpretation. Therefore, if the United States Supreme Court were to look at this clause and give it a textual interpretation, the result would be that the right to free speech and expression would be absolute, because it simply states, Congress, that is Parliament, shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press. Congress shall make no law abridging the freedom of speech, full stop. Absolute. Congress shall make law abridging the freedom of the press, full stop. Absolute. But that's not the case. And here's why. The First Amendment passed the House and the Senate with practically no recorded debate, and thus the intent of the framers was not entirely clear. Did they intend for the right to free speech and expression be absolute? Now there was a confusion in the intent. Therefore, the second rule a more purposive interpretation, a non-textual interpretation, if you will, that focused more on the spirit of the enactment rather than the letter, was necessary. Through a series of judicial pronunciations, its scope has been widened, and some of the principles expressed in these judicial decisions have been adopted by different nations around the world, including our very own India. Now, just because the text is abstract and the intent was not clear doesn't mean that the Supreme Court of the United States has essentially restricted the right. In fact, it has even expanded the right. Therefore, it has gone in both directions. And there are some landmark cases that are worth considering in a little bit of detail that can help you understand the scope and ambit of the right in the United States. Let's start with the landmark case of the United States versus Schwimmer. The case concerned Rosika Schwimmer, who was a pacifist. A pacifist is a person who believes that war and violence are unjustifiable. The United States of America, as many of you know, has and continues to fight many wars. Rosika Schwimmer had applied for American citizenship. Getting American citizenship is a dream for many citizens around the world, and many individuals around the world, and it was no different for Rosika Schwimmer. Anyone who wants to become an American citizen today has to pass a test and also has to take the oath of allegiance, whereby they essentially swear allegiance to the United States of America. While taking the oath of allegiance, Rosika Schwimmer was asked whether she would raise arms in defense of the United States. Rosika Schwimmer was asked whether she would raise arms, whether she would fight, literally, for the United States. She answered in the negative, and she was denied citizenship. It is a requirement that you must take the oath of allegiance in letter and spirit. And if you do not, you cannot be granted citizenship. And Rosika Schwimmer, for refusing to take up arms in defense of the United States, was denied citizenship. Schwimmer challenged this in the Supreme Court, and Schwimmer lost. And here's why. Justice Holmes dissented with the majority who found against Rosika Schwimmer. Justice Holmes strongly defended unpopular speech by stating that freedom of speech extends to protecting speech that we despise and not speech that we would like to hear. According to Justice Holmes, Rosika Schwimmer was being honest enough to state that she would not take up arms in the defense of the United States, and her refusal to swear by that part of the oath of allegiance was protected by the First Amendment's free speech clause. In the words of Justice Holmes, quote, some of her answers might excite popular prejudice, but if there is any principle of the Constitution that more imperatively calls for attachment than any other, it is the principle of free thought. And this is the key. Not free thought for those who agree with us, but freedom for the thought we hate, unquote. It's all well and good, Justice Holmes said, agreeing with somebody. It's all well and good to say that an individual has a right to free speech and expression as long as he or she is saying things that are pleasing to your ear, that are pleasing to the state. But the true test of a state or a nation or a constitution's free speech credentials is the protection that that constitution offers to speech that is hateful, speech that is wrong in their eyes, of course, speech that they disagree with primarily. As Voltaire, the French philosopher, said, one can disagree with what someone says, but one should fight for their right, in fact die for their right to say it. And that's what Justice Holmes was trying to say here. He said Rosika Schwimmer had every right to say that she would not take up arms in defense of the United States, and she should not be denied citizenship on the ground that she refused to swear on that part of the oath of allegiance. However, his opinion was a minority, was the dissenting opinion, and the majority held that Rosika's failure to swear by the oath of allegiance, to take the oath of allegiance, meant that she could not be granted citizenship, and the free speech clause, free speech protection under the First Amendment did not extend to her refusing to take the oath of allegiance. Another landmark case is Terminello versus Chicago. The petitioner, Arthur Terminello, in this case, was a Catholic priest who, while delivering a speech to the Christian veterans of America, extensively criticized various racial groups and made a number of provocative comments that amounted to hate speech. The place where Mr. Terminello delivered his speech had accommodated approximately 800 people. And at the same time, a crowd of 1,000 people were outside the venue protesting Arthur Terminello's racist and hateful speech, in their view. The situation got out of hand. The police could not maintain order. The petitioner was subsequently charged and he was found guilty. The petitioner here being Arthur Terminello, found guilty under Chicago's peace ordinance, and he was asked to pay a fine of $100 for a breach of the peace. Arthur Terminello challenged his conviction, and eventually the case reached the apex court, the Supreme Court in Washington, D.C. In D.C., the Supreme Court reversed his conviction, as it was held that his speech was protected under the First Amendment. Justice Douglas, in his famous majority opinion, goes on to say that free speech best serves its purpose when it invites dispute and unrest. Again, this judgment of Justice Douglas lays out the importance of dissenting speech, of speech that a majority of citizens might have a problem with, a speech that the state might have a problem with, because the very purpose of the First Amendment is to invite dispute and unrest, so that each individual can make up his or her mind on whether that speech or the opinion therein is true or untrue, or valid or invalid. Justice Douglas's judgment is worth reading in full. For now, let me quote a passage from it. Justice Douglas writes, and I quote, "Accordingly, a function of free speech under our system of government is to invite dispute. It may indeed best serve its high purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger. Speech is often provocative and challenging. It may strike at prejudices and preconceptions and have profound unsettling effects as it presses for acceptance of an idea. That is why freedom of speech, though not absolute, is nevertheless protected against censorship or punishment, unless shown likely to produce a clear and present danger of serious substantive evil that rises far above public inconvenience, annoyance, or unrest. There is no room under our Constitution for a more restrictive view, for the alternative would lead to standardization of ideas." Unquote. Justice Douglas's judgment is instructive, as it highlights the strong, strict protection, the high bar that the state has to meet in the United States of America to restrict an individual's speech. It cannot just be mere unrest. It cannot be mere anger or inconvenience or mere offense. There has to be a clear and present danger, the clear and present danger test, as it's come to be known. A danger of a substantive evil, basically, whereby lives might be lost. That's how high the bar is set in the United States of America, where the freedom of speech, thanks to judicial decisions, is near absolute. Let's look at this other case, where Gregory Lee Joey Johnson, who was a member of a political organization and was participating in a demonstration protesting against the policies of the Reagan administration. In this case, Joey Johnson, upset with the Ronald Reagan administration in the 1980s, got hold of an American flag, which was stolen from a flagpole outside one of the buildings where demonstrations were to be carried out. Johnson reached the venue of the protest with the flag, and he set the flag on fire. Something like this would be unthinkable in India and is punishable by law. Desecrating the Indian flag is an offense. but not so in the United States. The flag burning by Johnson was accompanied with chants of America the red, white and blue, we spit on you, you stand for plunder, you will go under. This chant offended certain people observing the protest. Johnson was subsequently charged with the desecration of a venerated object under the Texas Penal Code and was sentenced to 1 year in prison with a fine of $2,000. Johnson challenged the sentence on the ground that burning of the flag was a form of expression protected under the First Amendment. Johnson won. His contention was upheld by the Supreme Court in a landmark judgment, who held that the burning of the flag was Johnson's way of expressing his dissent, his dissatisfaction with the Ronald Reagan administration. So students, we now come to the end of this module. Let's quickly recap what we've learned. We've looked and traced the origins and the evolution of the right to free speech and expression from the time of Plato, Socrates, Aristotle and Chanakya through the Declaration of the Rights of Man and the First Amendment to the US Constitution. We've also looked at certain cases from the United States of America. It can therefore be seen that the right to freedom of speech is not a recent phenomenon. It has been in existence since time immemorial, and in fact, this right has gained more legitimacy as time has progressed, more protection. As democratic regimes continue to prosper, continue to develop, it is beyond any doubt that this right's scope will expand even further. And having an understanding of its development through the centuries will help contextualize and help you appreciate, and hopefully has helped you appreciate, modern day developments with regard to free speech and expression.